that's to provide us with as much experience as we possibly need to know about the criminal bar. This event, as I said, it's all to do with the criminal bar, about how we can succeed if we are aspiring to be criminal barristers, and just to learn more about what to do going forward. So how the event will run is that for about an hour or so, I'll be asking the speakers set questions that we've planned beforehand. And after an hour, we'll be putting everyone into these networking sessions using breakout rooms. The breakout rooms will run for about 40 minutes. And after 10 minutes, you'll get a new speaker in your room. This is to ensure that you have a chance to ask all the questions you want to ask. And if you have any questions throughout the 1 hour that I'm asking questions, make sure you keep a note of it. And throughout the breakout rooms is when you will have a chance to answer and ask those questions. So someone has asked if the event's going to be recorded, and yes, it is being recorded as we speak right now. The breakout rooms will not be recorded for obvious reasons. So we're joined today with Jeremy Dean QC, Mary Pryor QC, Real Jones QC, and Simon Clements, ex-director of the CPS. So I would have given an introduction, but I feel like all the barristers will be able to give a better introduction of themselves. So starting with Jeremy, if you can please give a brief introduction.
That wasn't a good start. I was muted. And one thing barristers don't like to be is muted. Good evening, everyone. Thank you very much to Tejal, and well done again for arranging this event. A brief introduction of myself is as follows. I was actually born in East London. I am a real life Cockney, born within the sound of the Bow Bells, in fact, born in Bow, although unfortunately I've lost my accent. I was state school educated in the East End of London, and I went to Queen Mary College between 1978 and 1981, had a fantastic time at the law faculty, which at that time was situated sort of halfway down the Mile End Road. It was a building on its own, and the most memorable aspect of it was an amazing East End pub across the road called the Fountain, where we spent most of our university days. Great memories of QMC, as it was then called. And fortunately, I linked up with Tejal, I think a few months ago now, when the Criminal Justice Society was reborn, and a fantastic job is being done. Following my time at Queen Mary College, I decided that I wanted to be a criminal barrister, although my first 6 months pupillage was in employment law in the chambers that Tony Blair was then in as a young barrister, and no one could predict, of course, at that time how history would unfold. And then to Queen Elizabeth Buildings, which was a very establishment set where I was not taken on as a tenant. I ended up in a tiny set of chambers in Gray's Inn, 11 South Square, which was probably one of the first ever diverse sets of chambers, a conglomeration of rejects from establishment chambers with a significant number of ethnic practitioners. At that time, diverse chambers were an unknown concept and very much a scorned upon concept. That is now 25 Bedford Row, the same chambers, and we have over the decades become a mainstream, I hope, leading set of criminal defence chambers with practitioners from all walks of life and an extremely high percentage of state school educated and practitioners and people from all aspects of the community. And our speciality is criminal defence of all kinds. Over the years, we've done everything from shoplifting to war crimes, all types of criminal defence imaginable. My practice has always been that of criminal defence, starting in the magistrates' court back in the 80s, working my way up to small Crown Court trials, burglaries, robberies, drug offences, that type of thing. And then, as is the hope of all criminal practitioners, more sophisticated types of work, culminating in becoming Queen's Counsel in 2003. Most of the work that I've done since then has been homicide and a lot of appellate work, which is what I always really enjoyed doing, and then becoming a Crown Court recorder in 2004, which has been a fascinating gloss on my career. And I'm extremely proud to be joint head of 25 Bedford Row. And for those of you who want to ask any questions about my chambers or any aspect of criminal practice, then as Teshad has said, that's precisely what this evening is for. So that's my introduction.
Thank you, Jeremy.
Right.
Mary, if you would like to introduce yourself.
Good evening, everybody. My name's Mary Pryor. I'm a criminal Queen's Counsel and I practice from the 36 group, which is in London. We used to be almost next door neighbours to Jeremy's set at 25, but we've just moved into the Gray's Inn complex. My background and route into the bar are slightly unusual. I grew up in Stoke-on-Trent in a council house. My dad was a coal miner. My mum packed tiles in a factory. I went to the school with the highest juvenile crime rate in my county. And my aim during that time was to not get pregnant. I managed to achieve that and then went on to do my A-levels at college. I then went to a polytechnic near where my sister lives. I worked 2 jobs. One of the reasons was that my dad died in the middle of my second year of my degree and there was no money to pay for his funeral. So between us, there were 5 of us, we did that. When I finished my degree, I knew I couldn't be a barrister because people like me couldn't achieve that. So I worked badly and uselessly for a year in industry. And I then got a job as a magistrate's court clerk. And it was that job after 6 years that enabled me to qualify as a member of the bar. The reason I ended up being a member of the bar was the solicitor's course was full. Once I got there, I realized actually I wasn't as bad as I thought I was at this sort of thing, and in fact seemed to be doing rather well. At that time, you had to pay for pupillage. There was no means on earth that I could do so, but I had the great good fortune to be offered a sponsored pupillage with the Crown Prosecution Service. I spent 6 wonderful years there. And then with a 3-year-old, a 2-year-old and a baby, I went to the bar. The reason I went to the bar was I got a small amount of redundancy money from CPS who were getting rid of staff at that stage. And I knew it was then or never. I applied to every chambers that I could find in any directory. I got 1 interview with a very small set in Clock Chambers in Wolverhampton. I took that and the rest, as they say, is history. My practice now is about 50-50. I prosecute about 50% of the time and I defend 50% of the time. And I've now taken silk. What else? I'm also a Crown Court recorder and I'm a recorder in family, and that's both public and private. And for reasons entirely unbeknownst to me, apparently this year I am Woman of the Year. So that is me.
Thank you, Mary, and congratulations for that. Can we have Riel giving an introduction of herself, please?
So like others, I came to the bar by, my name's Riel Carmi Jones. I came to the bar by a rather unconventional route as well. My mother's mixed race Palestinian and my father's Welsh, and I grew up in Canada, where I started out studying drama. I went to university and did a degree in theatre and English, and then came here to the UK as a Canadian to pursue a career in theatre. I went to drama school and ended up staying on working in theatre for about 7 years before I decided towards the end of that period, to make a change and go back to university, bearing in mind I had no A-levels or GCSEs or anything like that, but to go back to university to study law, which I did as a mature student. I had to work through my degree, like many do, to make ends meet. And at the end of my degree, having not done very well in my first 2 years, I got a 2-1 really rather surprisingly, because I aced family law, not crime. I applied for articles in solicitors' firms. I didn't get any. I blagged my way into bar school. And like many, when it came to the end of that, I applied for every possible pupillage. I applied for criminal sets, I applied for mixed sets. I wanted to do crime, but had pretty little, not very much experience. And so I really just cast my net very wide. And I think I sent out 80 to 100 applications, which you could do in those days. And the rest is almost history. I did pupillage at what is now 2 Bedford Row, Bill Clegg's set, and then went on for a second six to QEB Hollis Whiteman. I'm not sure if that was Jeremy's QEB or not. I didn't get taken on at either of those 2 sets. And so I went and did a third six pupillage at what's now 2 Hare Court. I got my tenancy there and left there by choice in 2010 and moved to Red Lion Chambers, where I currently practice. I principally work in criminal law. The proportion of my work has been more towards the prosecution, but I do try and do both. And the type of criminal law I work in is the dirty side, the more dirty side of criminal law, more unpleasant kinds of offending. From murder to terrorism, sexual offences to modern slavery. I think my background in theatre has helped. It makes it easier to address a jury, to try and get to the psychology, if you like, of why someone might do something and explain that to a jury. I took Silk in 2015, and generally over the years, my practice has been quite varied. I've actually had the pleasure of working with the other members of the panel at one stage or another. As a junior, Jeremy might not remember this, but I was against him on what I think was a rape, might have been a murder trial, where a schoolboy raped a school teacher. Courtney, who was meant to be with us, I worked with as a junior on a terrorism case. Mary and I have recently crossed swords in a murder manslaughter case. And Simon and I have worked together on a case where a man impersonated Keir Starmer, our present leader of the Labour Party, to woo women through Lonely Hearts ads and then steal money from them. I think there was another case we did, Simon, but I can't remember it. And recently I took a very different course from crime, and I worked for about 2.5 years as lead counsel to the Independent Inquiry into Child Sexual Abuse, leading their investigation into the Roman Catholic Church and delivering their hearings into the English Benedictine congregation and their reports. Apart from that, I write for a couple of criminal texts. I write for Archbold and Criminal Pleading Evidence and Practice, and Rook and Ward on sexual offences. And that's about it, really. Kind of sums me up.
Thank you, Riel. Simon, if you can introduce yourself.
Good evening, everybody. My name's Simon Clements. I am an ex-criminal practitioner, as I retired from the CPS in September after 36 years mainly as a state prosecutor. In that time, I worked through various sections of the Crown Prosecution Service, but going back in time, I didn't study law. I studied Spanish, Portuguese and French, and then went and did the conversion course. So, you know, there are many different ways to start off. And my advice to undergraduates always is do the course that you're going to enjoy as an undergraduate. There's plenty of time. And for you poor young people, there's more than plenty of time for a career thereafter. I did a mixed first six pupillage. My pupil master did a lot of work and made me go and buy his tobacco and take his clothes to the dry cleaning every week. And then I met up with Jeremy in Queen Elizabeth Building. We were in what was Victor Duran's set, not the Hollis Whiteman set. Jeremy's far too modest to say that he was head and shoulders the best of our group of pupils and should have been taken on. But it's strange how life turns out, and it probably did Jeremy a great favour by not being taken on in an establishment set. He's thrived ever since then. Like Others, I couldn't get a tenancy in that set. And so I joined what was prosecuting solicitors at the time before the CPS was created, with a view to gaining some experience and coming back to the bar. I never did, because I had such a great time as a prosecutor, starting off in Berkshire, Buckinghamshire and Oxfordshire, prosecuting day after day of trials in the magistrates' court, and then moving up the management route, where I still managed to prosecute regularly, but also to lead and train and teach junior prosecutors. And so that's one of the things I've managed to do all my time. By the time I retired in September, I prosecuted in every police area in the country, 120 odd magistrates courts, over 30 Crown courts. So it's not just members of the self-employed bar who travel to do their work. You can do that as a state prosecutor. In the CPS, I've been a chief Crown prosecutor. I've run a casework division. When I met Real, I was in charge of a casework division, and yes, we had to prosecute somebody who did a very poor impersonation of Keir Starmer, and it was the early days of the internet, so I don't think some of his victims spend a lot of time looking him up, because I think he's probably better looking than the guy who was impersonating him. In that role, I also came across Jeremy in a professional way when he was defending a young woman who was convicted of stabbing a local MP at a constituency session. So yes, in some sense, it is a small world, and I was delighted when I saw the cast list for this evening to see that I'd hook up with some people that I'd met before, but also meeting Mary as well. So that's a bit about my career, and like Jeremy, very happy to take any questions about life as a state prosecutor and what it can offer as a slightly different career.
Thank you, everyone, for the beautiful introductions. So I'm going to start by asking Jeremy a question. What drew you to defence over prosecuting?
Okay, Tejal, I will answer that question, but can I very quickly just say this, because I was so keen to stick with the timetable. I do want to just say how pleased I am to be on the panel with my colleagues. Rial is absolutely right. I remember being in a difficult case with her. Mary prosecuted me at Birmingham Crown Court in what is a classically challenging trial about a year ago, maybe 2 years ago, the rape and murder of a woman, I think in her early 80s. That is the kind of thing we have to do. And it's frankly amazing to see Simon after so many years. We had huge fun in very difficult circumstances back in the early 1980s when the bar was unrecognizable from what it is today. It wasn't necessarily a very pleasant place to be in. It's great to see Simon looking no different than he did all those years ago. So that's what I have to say on that. The answer to the question, what drew me to defence over prosecuting, is quite simply this, that it's actually the only thing I thought I'd be very good at. I didn't actually do very well at school. I was pretty thick, actually, and I won't reveal what my results were because both at O-level and A-level, they're fairly embarrassing. But the one thing I was quite good at was public speaking. And as someone like my colleagues on the panel, and Mary's mentioned her background, you know, I came from a house, my father was a waiter, a very strong Labour foothold. You know, I really wanted to do something for the underdog. So I combined really the only skill I seemed to have, which was being, you know, a fairly good public speaker, with wanting to speak on behalf of the underdog. And that led me to an overwhelming desire to defending at the criminal bar. Prosecuting wasn't for me. I didn't want to represent the state. I didn't think I'd be very good at representing the state. I didn't have a passion for speaking on behalf of the state. That's not to undermine in any way the skills that involved. I just wanted to be a criminal defense advocate. And frankly, some 37 years later, I genuinely feel that it's the best decision I ever made. I've enjoyed the whole journey. And as Tejal knows, she's been with me at court over the last week or two in a very difficult murder case. It's an incredibly difficult but exhilarating occupation. So that's what drew me to defending over prosecuting.
Thank you, Jeremy. Now, I'd like to ask Mary a question. So as someone with a lot of experience, both prosecuting and defending cases, what do you think are the main differences between both of those work?
When you're prosecuting, the role that you play is to be fiercely independent and fair. It's not your job when prosecuting to get a verdict despite the evidence or at any cost. You have a role, and it's a very important role, to present the evidence, as I say, fairly and impartially before the court. And it is for the jury, having heard all the evidence, to decide. The work when you're prosecuting is really very much front-loaded. So there is an intense amount of pressure at the beginning of a case to get it right. And that involves not only making sure that all the witnesses who are going to give evidence are able to be heard, because in the same way that defendants have vulnerabilities, so often do people who are victims of crime or witnesses to crime. Some of them are children, some of them have communication difficulties. But also you have a special responsibility to ensure that the case is fair. So it's important to look at disclosure, and it's important to look at avenues of investigation early on, which may or may not have happened. When you're defending, your role is to be the voice of the person that you are representing, because they are not able mostly to speak for themselves. And your job is to fearlessly and determinedly challenge the evidence in the case in a very robust way if necessary, and to make sure that you can gain the trust and therefore work with a young person who, it's often a young person, it's often someone from the looked after system, it's often someone with their own vulnerabilities. And so that it is a dual role. Firstly, it is to try and get someone who has every reason to distrust you to trust you, and then to examine the evidence and to challenge it robustly. I know that I was taught that my role was effectively the same as a taxi pulling up at a rank, and that I have always, and I always have, taken the very next case that's come along, whether it is prosecuting or defending. Each of them has their own challenges, but it seems to me that that is the particular difference that I notice between the two.
Thank you, Mary. The question for real is, what challenges did you face when you were dealing with human trafficking and modern slavery cases?
I think one of the greatest challenges of those cases is in a way, it's a bit like Mary's just described the difference between prosecuting and defending. Prosecuting is often, building bridges, building blocks to put something together. Defending can also be finding the nooks and the crannies in those slots. And one of the biggest challenges in a human trafficking or modern slavery case is that the victims, it sort of turns defending and prosecuting on its head. So you almost have to approach a human trafficking case as if you're defending, because one of the issues is the victims themselves. Victims have very often been selected by the people who are trying to exploit them for a reason. And that is because they are, by their very nature, inherently vulnerable. And that could be because they're young, they're poor, they're desperate, they're desolate, destitute, any or all of those things. Sometimes they may be not well educated. Sometimes they may be homeless, dependent on alcohol or drugs, without many options in life. Not always, but sometimes. I mean, you sometimes get people who are extremely well educated, who've fallen on hard times, but through other issues have fallen into, if you like, a trap. They may have criminal records, they may have been picked up off the street, so are people the authorities may be less inclined to believe, which is what the trafficker looks for. They look for someone who is less likely to be believed and who is less likely to have, if you like, the nerve, the guts to come forward to complain. they may also be people who have little reason to trust us, to trust the authorities. I mean, why should they? In many cases, they come from areas where there is known to be corruption. It may be someone who they perceive as being an authority who is actually their exploiter, their trafficker. So why should they suddenly trust authorities here if they've come from another country, say? So getting victims to come forward, getting them to trust the police and the prosecution in a trial process is very difficult, and not least because sometimes they themselves don't even understand that they have been exploited. So I think that's the most difficult part of human trafficking cases.
Thank you, Riel. So a question for Simon is, for a student trying to decide whether to undertake a CPS pupillage or within chambers, what would you advise them to consider? And what sort of person do you think would be better suited for a career within the CPS?
Well, first of all, I think that whether you join the CPS, the government legal service, or a set of chambers for a criminal pupillage, in this country, you will be very fortunate. I've never met anybody in my acquaintance at the criminal bar or the CPS who won't help somebody out who's starting off. So I think in that sense, there's no real choice between it. If you're somebody who is perhaps more comfortable within an organisation, then the CPS may be for you. Also, if you want to play the odds, we offer between 40 and 50 pupillages most years, which is significantly more than many chambers are now in a position to offer. So you're hitting a bigger target, and the CPS does not expect that everybody will stay with them. That's not the way it's done. So I think a lot of people don't realize how many training opportunities there are. And one of the benefits of being in an organization is that there are people whose job it is to make sure that you get your training. Again, panel members and those in their chambers will make sure that all trainees get a fantastic range of experience during their pupillage, so that come day one of their second six, they're ready to go into the magistrates' courts and do some advocacy. In terms of opportunities, the structured way a CPS pupillage works means that we make sure that people go out to defence chambers wherever possible, or a defence solicitor's firm, because the one thing we cannot offer during our pupillage is the opportunity to defend people, because we're the state service and that wouldn't be right. But pupils of mine have been and spent time at the Attorney General's office, so they'll work on unduly lenient sentences, contempt of court cases, Coroner's Act cases. They might work in CPS policy, learn a bit about policy making, statute making, how policy is converted into practice. They might work in one of our casework divisions, maybe spending some time looking at terrorist cases or serious fraud. Most of my pupils have spent time marshalling, which is sitting with a Crown Court judge or a district judge to learn from them. And also some of mine have been and spent time in chambers on the training packages that chambers have put together for their pupils. I had a quick look through I've had 16 trainees in my time. The last few currently, one's at the extradition bar, one is a rape and serious sexual offences lawyer in Kent, one is a Crown advocate in the Crown Court doing Crown Court work in the CPS, one has just returned from maternity leave having 2 young children, one is an extradition lawyer within our casework divisions, and my most recent one is a reviewing lawyer in a busy Crown Court team in London. So that gives you just a quick flavour of the sort of opportunities if you either remain or go on and do something else. If you like working as part of a team, CPS may be for you. If you like constructing cases, as Riel said earlier, our job is to construct cases. If you have a passion for prosecuting the right people, but also making sure that people who should not be prosecuted are not prosecuted, that is a huge part of the role of the State Prosecution Service, and why we were created just before Jeremy and I started practicing The 1981 Phillips Commission is worth a read if you're interested in criminal history. The variety of work, you're part of an organisation, you can move around the country. And if you like job security, a job with the CPS gives you 6 weeks paid holiday a year, a pension, and the opportunity, if you wish, to exercise higher rights. But there are fewer opportunities. So if advocacy is really something you want to go for, self-employed bar is probably for you. So those are some of the things that I'd highlight that we offer that may be different from what people think about generally.
Thank you, Simon. So going back to Jeremy, would you say that those accused of committing a crime get the fair trial that they deserve? And is the trial system tipped too in favor of one side or the other?
Tejal, in relation to the first part of the question, would I say that those accused of committing crimes get the fair trial they deserve? My answer to that question is, in the main, I think they do get the fair trial they deserve. Our system of trial does come in for criticism, and I'm, as a defense lawyer, someone who has to launch criticism whenever I can. If people are convicted, then appeals generally involve criticism of the trial system. But I think in the main, our trial system is geared up to trying at least its very best to give the prosecution maximum opportunity to state its case, to allow the victim to feel that the issues in the case are being fully ventilated, and at the heart of that, the complaint advanced by the victim or victims are fully and comprehensively put before the court. And from my perspective, of course, the position of the accused, the defendant or defendants, are of paramount importance. And I think on the whole, our system is geared towards a satisfactory, open, balanced system of fair trial. So the answer to the first part of the question, whether those accused of committing crimes get the fair trial they deserve, in principle, is yes. The second part of the question, which is obviously closely related, is the trial system tipped too far in favor of one side or the other? I think the answer to that question, I mean, I don't want the second response to be regarded as inconsistent with the first, but as a freestanding issue, I think the trial system remains tipped too far in favor of the prosecution. Firstly, although the judiciary has changed unrecognizably from what it was at the time that Simon and I were hanging around Middle Temple Lane wondering what on earth we were going to do with our careers. Nevertheless, the judiciary is still residually prosecution-minded, and therefore the general atmosphere of trials remains, to an unacceptable degree, prosecution-orientated. I also feel strongly that it's unfair that the prosecution have the right to a full opening, whereas the defense do not, which kind of sets the scene for the trial and straight away allows the prosecution to dominate the trial. And generally speaking, judges tend to favor the prosecution in terms of their rulings and the general atmosphere of cases. It's much more complex than that. I want, again, to stick with my time limit, which is a couple of minutes. So yes, I think the trial system is tipped too far in favor of one side or the other, but I do think we have a fair trial system which we're entitled to be proud of in this country. And that, of course, is, as a general principle, a very important thing indeed. So those are my responses to that two-part question.
Thank you, Jeremy. A question for Mary is, what do you think are the advantages of prosecuting rather than defending?
Imagine a scenario where you have been given the role of prosecuting all of those who have sexually and physically abused people in children's homes over the course of 20 years. What you do in that scenario is build a teamwork between yourself, the Crown Prosecution Service, and the officers investigating that. And you can end up with something like this. The first lady in Operation Daybreak, which was the Nottinghamshire children's homes cases that I prosecuted over a course of 2 years, went into care at 11 because she had been habitually raped by her stepfather. Once those within the care system knew about that, they also habitually raped her and then sent her out to prostitution. She became a sex worker. She became addicted to drugs and alcohol. She had her children removed from her. And by the time I met her, some 20 or more years later, she very much resembled someone who had gone through all of those life experiences, unable to make eye contact, slightly unkempt, very untrusting. Having met her and spoken to her, we prosecuted her stepfather first. He got 25 years. He'd already, in fact, been prosecuted for raping another child in another family, but nobody took the trouble to ask her whether anything had happened to her, because by that stage she was in care and deemed to be troubled. The second trial we did related to the social worker who had habitually raped her. He got 28 years. By the time she came for that trial, she had transformed as a person. She walked in with her head up. She looked me in the eye. She gave good evidence, and she was cross-examined robustly, properly, but robustly. At the third trial, she was an elegant, self-confident lady and dealt with that case. And she now goes around to various police forces, talking to them about how police forces can better look after the victims of institutionalized and habitual abuse. To be a very small part of that is a real advantage in life. It's a real privilege. And so victims can be vulnerable. They can require assistance. And to do so, it is in many ways the best job in the world.
Thank you, Mary. So a question for Riel is, would you say that the law on human trafficking and modern slavery in the UK are sufficiently reformed?
I would say that there is always room for improvement. The Modern Slavery Act has made great strides in drawing together the strands of the previous legislation and law, and recognizing that modern slavery is for what it is. But I think personally that it is flawed. It could do with some revision. One area which has caused problems, for instance, is that the legislation doesn't itself contain any statutory definition of what each of the elements or the potential offences are. So, for example, there's no statutory definition of slavery, servitude, or forced compulsory labour. Human trafficking relies perhaps too much on the transportation of a victim, and there is no standalone offence of exploitation. On the one hand, the way it's approached means that there's flexibility in the application of facts and definitions. On the other hand, it means that there is less certainty, which means that at the beginning of a case, we inevitably spend a fair bit of time on scrabbling around complex European legislation and the other various authorities that there are, trying to work out the issues and how they apply to the particular facts in question. For example, to what extent a victim's consent may or may not be relevant. So always room for improvement. I think that it could do with a bit of a redraft.
Thank you, Riel. And now back to Simon. How has the situation with the lockdown affected the Crown Prosecution Service, given the initial restrictions with funding?
To answer that question properly, you have to go back a few years. In 2003, the Crown Prosecution Service invested in a case management system, which enabled the CPS to start creating electronic files some 8 years ago. About 5 years ago, there was introduced into the Crown Court what's known colloquially as the DCS, which is effectively a digital trial bundle in the Crown Court, and the ability for the parties to exchange information, documents, and messages with each other electronically. If you don't have that sort of infrastructure in place, when you hit something like a lockdown, you will struggle. I'm currently doing some work with prosecutors in Kosovo who entirely rely on paper, and it has been almost impossible for them to keep things going during lockdown. We also made sure that all our staff, so prosecutors and administrators, all have their own laptop through which they can link into our system from any place that they can get a broadband signal. So on the 17th of March, 95% of our staff moved from working in an office environment to working from home because we had the infrastructure in place to be able to do it. Those that were working in the office were mainly, strangely, converting discs from the police onto a digital system so we could share them with other parties. Apart from that, most people were able to do all the case management processes from home. Of course, our prosecutors were continuing to appear in Crown Courts and Magistrates' Courts, but there was a exponential growth in remote hearings, initially through Zoom or Skype, but now more commonly through the video platform that the court service has introduced. I was responsible for our training at that time, and we moved all our training and converted it into online training, just as you've probably seen the Inns of Court have also been doing as well. So if you invest in the infrastructure of systems and the way people work, you're able to move to it. I'm not saying it's been easy. Anybody who's been to a court recently or spoken to anyone in the criminal justice system will know that there are awful backlogs, and it's going to take a significant amount of time to get through those. Those are because of the physical limitations imposed on the court environment at the moment. And many people in the system are spending time revisiting cases that are being listed on a number of occasions in what turns out to be the vain hope that they'll be reached. And people are spending a lot of time, as I call it, reheating cases to try and get them ready, but never being able to serve them. So on one level, we were able to function as near normal as possible, but it's within what is effectively a broken system at the moment in terms of getting people to trial. And for victims and witnesses, the prospect of them having to wait even longer is not something that is particularly something that this criminal justice system can be proud of.
Thank you, Simon. So a question for Jeremy is, what are the skills required to appear for the defense in the Court of Appeal? And do defense lawyers generally like to appear there?
I keep muting myself because I fidget a lot and tend to ruin events like this if I don't, so I apologise. The second part to your question is, do defence lawyers like to appear in the Court of Appeal? I found over the years that the answer to that question in the main is no, they do not. Most defence counsel appear not to relish the prospect of going to Court of Appeal. Certainly, when I used to go to the Court of Appeal towards the beginning of my career, in the middle of my career, it was a thoroughly unpleasant place. You know, the judiciary was very, very establishment, quite rude, blunt, bullying, and the prospect of going there to criticize other judges was not an attractive one, and it required a great deal of courage. Once again, it's still an intimidating place, and most defense lawyers don't really enjoy going there. for whatever reason, it's not for me to say, probably need to be psychologically or psychiatrically examined in order to identify the reasons. I love going to the Court of Appeal. I find it a real challenge and quite an exhilarating experience. Even though, generally speaking, when defence counsel go to the Court of Appeal, the presumption is that you won't get a positive result. The skills required to appear in the Court of Appeal for a defence lawyer are completely different to those to be utilised in the Crown Court within the trial process. So far as the trial process is concerned, it's generally speaking all about advocacy, although there's an element of legal argument. The principal role is that of the jury advocate and the skills of persuasiveness on the facts of the case. Whereas in the Court of Appeal, it's very much about marshalling your arguments in a concise, cogent, attractive way, making sure that you crystallize the issues in writing before. Time is of the essence in the Court of Appeal. Generally speaking, you're appearing before judges, very high intellect. They're not generous in terms of responding to arguments which are not well-founded or not properly formulated. So the skills required are very much fine-tuning what you have to say, making sure you know exactly what proper arguments there are to advance, being 1000% on top of the factual aspects of the case and the legal aspects of the case, and standing your ground, because very often the decision is made before you even get there and you get a cold reception. So standing your ground, being relentless and fearless as to your arguments, but nevertheless economical and appropriate in the way you present your submissions. So on the face of it, it's not a welcoming environment, but if you like legal argument and you enjoy challenges in life, it's definitely the place to go. But the skills required as between the Court of Appeal and the trial forum are fundamentally different.
Thank you, Jeremy. A question for Mary is, what do you think is important to take into account, and what do you do differently when questioning vulnerable people?
Well, that's a big question for 2 minutes. The thing to remember with vulnerable people is it is all too easy to trick them, and it is a trick, into answering questions with the wrong answer. And this is particularly the case for young people accused of crime. There's been a tendency over the years to cross-examine young people, and young can be anything from 10 up to, I think, 25. There's been a tendency to cross-examine those people in an aggressive way, which consists of making statements and putting a question mark at the end of it. A very simple example is, you did it, didn't you? And one of the things that we have had to learn, and we've required assistance from experts in psychology, psychiatry, and education, is that those questions don't get reliable answers from people with vulnerabilities. Because they can be answering yes when they mean no, they can be answering no when they mean yes. And so the really important thing when questioning those with vulnerabilities is to ensure that you follow the relevant toolkit that applies to that vulnerability. And there are a number of advocates' toolkits set out on the Inns of Court College of Advocacy website. They're freely available and they cover all vulnerabilities. But not only do you have to do it, you will have a real struggle to persuade your opponent to do it, and also to persuade the judge to do it. I recently defended the youngest person in this country accused of terrorism. my opponent was an expert in terrorism, but my opponent was not an expert in questioning children. And it showed. And my opponent really tried very hard not to follow the rules in relation to questioning a person with those vulnerabilities. And I'm afraid I had to be very stern, both with my opponent and with the judge, neither of whom really wanted to believe that the old ways were not the best ways. So the real problem with questioning people with vulnerabilities is ensuring that you are asking questions that they can answer, and you ensure everybody else does the same.
Thank you, Mary. So a question for Real is, in your vast experiences working in the field of human trafficking, how do you deal with cases where victims are defenseless and refuse to testify?
Well, the first thing to say is usually by the time a case comes to me, most of the victims have come to a point where they have become willing to testify. But in general answer to your question, that there are many different things that need to happen. The first port of call is for the police who are conducting the investigation to develop a good rapport with a victim so that the victim trusts the process. And as I said earlier, that can be quite hard. I did a case some time ago where the police worked with a victim, and that might, ring bells for some in the defense side, but not dealing with their evidence as such, but drawing them out and encouraging them that they could trust them for about 2 years before the matter was able to come to trial. So the first port of call is the police to develop a good rapport with the victim, or the police liaison officer, rather. The victim needs to know and be told that it's possible to apply for special measures, and that their concerns can be abated a little bit by special measures that may mean that they can either give evidence from a different room over a TV link, or from behind a screen so that they don't actually have to see their exploiter. That needs to be made clear to them. Personally, once we get to the stage of embarking on a trial, I try and make sure that I meet a victim. I would do that not just in a human trafficking case, in any serious case, to explain the process, to answer any questions that they may have, not to discuss the evidence, of course, but to do my best to ensure that they are put at ease. Sometimes people don't want to attend. If they don't want to attend, it'll be because of their circumstances, because of the community that they are in, and the fact that they don't want to be seen to be helping the prosecution authorities because of possible repercussions. And in those instances, you can take an extreme course of applying for a summons, which often helps them. So, for example, I did a case where the victims were Slovakian Roma women who worked in prostitution, who were in principle happy to give evidence, but they needed to be seen to be made to give evidence, so as not to be ostracized within their community for assisting the police. So really it's a step-by-step process, and you start from the very beginning, the very first engagement with a victim, ensuring that they understand what is to come and doing your best to put them at ease.
Thank you, Real. And a question for Simon is, due to low convictions in rape flagged cases across England and Wales, the recent reform made by the CPS is to allow adult rape complainants to give evidence and be cross-examined via a video before trial. How can this lead to the increase of the willingness of victims to pursue complaints?
Well, I think what you're referring to is commonly known by practitioners as Section 28. And it's actually quite an old provision. It's part of the Youth Justice and Criminal Evidence Act of 1999, but it's taken us all this time to get it into practice because of problems with funding the process. if you look back, I'm old enough to remember when I started practicing, before 1988, there were no provisions in Crown courts in this country for children to give evidence other than in the courtroom. It was only 1988 when a limited introduction of video links was produced. And in that time, we've come a substantial way. There's still far more to go. But we now have many measures that when I started practicing just wouldn't have been considered. Screens, intermediaries. We understand a lot more about the process of questioning than we used to. Mary's absolutely right. I remember with shame a case I did when I was a young prosecutor, when I was prosecuting a youth for robbery. It was a relatively minor robbery in the sense it was robbery of somebody else's pocket money in a playground. And I cross-examined him for half an hour. And eventually he admitted the offence. The youth court acquitted him. They thought that I had gone too far, and they were absolutely right. Half an hour questioning a 14-year-old who I now recognise probably had learning difficulties was not the way to do it. If I'd just done the job properly, they would have convicted him and dealt with him. So you often learn lessons through practice. And we must also remember that the Equality Act of 2010 requires the criminal justice system to allow people properly to participate in criminal proceedings. There's a safeguarding responsibility on judges. I think one or two of them sometimes would be well reminded of that. And the Section 28 provisions, coming back to your question, allow victims to give their evidence relatively quickly, fairly soon after a case has been sent or allocated to the Crown Court, to be cross-examined, and then in a way to be able to start the process of putting the case behind them, because they don't have to come to court for the trial. It's fair in the sense that the defence cross-examination takes place in the same way. So in that sense, they're given an opportunity to ask the questions they would have asked in any event at a trial, but with all the safeguards that have now come in. So it's not in properly. I think it's only in now in about 8 or 9 Crown courts across the country. And then when it's in properly, it'll be evaluated. But it's not about raising the conviction rate. It's about making sure that fair trials take place.
Thank you, Simon. So now a final set of questions before we go into the breakout rooms. Firstly, for Jeremy, you are a recorder as well as a defence barrister. How difficult is it to switch roles, and are the challenges different?
Okay, Teja, I am a defence barrister. That's all I've ever done so far as practice is concerned. But I'm also a recorder, and I've been a recorder, as I said, since 2004. And as a recorder, my role is unrecognisable from what it is as a practitioner. Fun enough, I have not found it difficult to switch roles. Prior to becoming a recorder in 2004, having been called to the bar in 1982 and having practiced as a defence lawyer for 20 years, I found it surprising that I didn't have difficulties in switching roles. But that is the simple answer to that first part of the question. I didn't. And I hope the message there for people attending is that flexibility within the criminal justice process is perfectly feasible and possible because I have experience of it. Are the skills and challenges that face the defence practitioner and a judge, part-time judge, different? As I've said, they are completely, totally and utterly different. As a defence lawyer, the requirement is to be proactive, to be passionate, to be combative, to be fearless, to be relentless, to be in the front line of the proceedings, protecting the interests of your client every second of the process and the trial in particular. As a judge, what you're required to do if you want to be a really good judge is to say as little as possible, not to intervene, to fade into the background. And it's often said, and I firmly believe it, that those are the judges who are the best judges. So the challenges that you face as a judge are obviously to do your absolute best to be impartial, to ensure that the trial is fair, not to be in any way partisan, in effect, to have no interest, express or secret in relation to the outcome of the proceedings. And finally, what I would say is to anybody who does go to the bar, especially as a defender, that it is a fantastic experience to have the privilege of sitting as a judge as well, because not only does that give you an opportunity to vary your professional skills, but it also tells you a lot about your inner self and your ability as an individual to draw upon personality features which in your day job, my case a defense barrister, you don't normally draw upon. So if ever any of you delegates attending tonight have the opportunity to do both, then I strongly recommend it.
Thank you, Jeremy. We'll take that into consideration one day.
Thank you, Tejal.
So a question for Mary is, what are the common biggest obstacles to securing convictions in homicide cases involving children victims?
The major difficulty is often that the household consists of more than one parent. And where you have the death of a child who was being looked after by more than one person, you can see immediately, unless one of those two people confesses, and even then one has to be careful about confessions in such circumstances, that you can sometimes leave a jury in an impossible position of having to decide whether it is carer A or carer B who is ultimately responsible for the death. The other difficulty that can arise in such cases is that, very sadly, children who are physically abused are often in families where a vulnerable carer of that child is also physically abused, but may be so conditioned that they are still protecting the person who has abused them and abused the child. And so it's very difficult to see through all of that and to make the right choices. The other difficulty in such cases is often that there are very few experts available now who will be willing or able to give you proper medical advice and opinion as to how deaths occurred. And because of the unfortunate limitations on criminal legal aid funding, both for the prosecution and the defence, the pool of people available to give that advice is smaller and smaller. And it means that you may wait very long indeed before getting any report at all. The other difficulty, of course, finally, is that such cases give rise to great emotion. And it's really important when prosecuting in those cases to ensure that verdicts are based on evidence and not emotion.
Thank you, Mary. A question for Real is, do you think that the issues surrounding modern slavery are downplayed in current society in contrast to prevalence in the past?
I think I can take that one quite shortly. The answer is no. I think quite to the contrary. I think we have a much more heightened awareness about modern slavery now. I guess it depends how far back you go, but certainly modern slavery has become a go-to offence, and there are warnings in every hospital, doctor's office, social services. People are much more alert to modern slavery type offences now than they were, say, 30 years ago. So no, I don't.
Thank you, Riel. And finally, for Simon, this is in follow-up to the previous question we asked you in regards to the videos. Will this reform lead to increased convictions of sex offenders?
I think at times the focus on the conviction rate can lead to perverse consequences. If you think about it, if we had 100% conviction rate of cases that went to trial, people would complain that the CPS and the system was just prosecuting very easy cases. If at the other end of the scale, the conviction rate after trial was about 10%, there'd be questions asked about our efficacy. If you look at the rate of acquittals in jury trials going back to before the CPS was created, back to the 80s and the 70s, the level of acquittal after trial is roughly the same as it always has been, just over 50%. So it's about making sure that the right cases are prosecuted and that they are put to the court properly and firmly, but that people have proper representation as well, and ultimately so that juries can decide what the outcome should be. Looking just at conviction rates, I think, can lead you down a difficult path. I think looking at some of the reasons why fewer rape cases are coming into the system, particularly over the last 4 years since the exponential growth in social media, I think that in a way is our bigger problem, our bigger challenge in trying to make sure that people get a fair trial, but also that victims aren't scared of making a complaint because they fear that all their life is going to be laid bare in the criminal system. So it's not just about conviction rates, it's making sure that the right cases get processed and put before the jury.
Thank you so much, Simon. Thank you to all the speakers. Now we will be going into the breakout rooms, which kindly Hamza has organized for us. So in a minute, you'll be getting a little bit of a notification on the side of your screen asking you to join one of the breakout rooms. And in 10 minutes time, we'll be switching to put another speaker in your room. This will go on for about 40 minutes, and then we'll all come back to the main stage. I'm actually wanting to know from the speakers how you found those.
You want to go in the same order, Teshal, as before? Yeah.
Any order is fine.
Okay, well, I'm going to hand over to my other panelists because I've dominated first slot throughout, so I'll go last on this. Let's
okay,
go.
I'll say something. I really enjoyed that, not least because it's a trip down memory lane. It made me think about things that I haven't thought about for a very long time. And I was asked some very good practical questions about how you manage some of the difficulties in dealing with very emotional cases and how you manage emotional witnesses as well. So I thought it was really good and I've really enjoyed it. So thank you very much for having me.
Thank you, Rio. Mary, I know you're waiting.
I'm waiting, yes.
Yes.
I think it was great fun listening to the questions and answering them and hopefully giving some answers that people will benefit from. But I think everyone who is on this Zoom meeting should congratulate themselves for coming out of their comfort zone and asking questions. That's all part of growing as an advocate. But the questions that I was asked were very good indeed.
Thank you, Mary.
I'd echo that. One thing you'll learn if you become criminal advocates is as you go down the pecking order, one DPP once said to me, if you've got nothing to say, don't say it. But of course, we're all advocates, so we will say something. But the point that Mary made is a really good point. If you want to become a really good first-class lawyer, whatever field of practice, you're going to have to get out of your comfort zone. You're going to have to ask difficult, sensitive cases, whether you're representing the state, the defense, an employer, an employee, and you need to do it sensitively. But practice, practice, practice. And it's been great to catch up with some friends I haven't seen for a while. So thank you, Tejal, for that opportunity.
Yeah, Tejal, in response to your question about the breakout sessions, I'm tempted to say that the experience was absolutely dreadful and the questions were really bad, just to say something different, but I would be lying, because the breakout sessions work extremely well and there were some excellent questions. My final word is this. I mean, I think all four of us here tonight, we all started out totally bemused about where our careers were going to take us. And I repeat what I said. I remember Simon and I used to hang around together an awful lot, and I don't think either of us had any real hope of being successful in our professions whatsoever. We just didn't really know what the hell was going on. So and obviously our two colleagues, Mary and Riel, have done incredibly well. So I think the message from all of us is just, you know, if it's your dream to be successful in the criminal justice system as a professional, as a barrister, then just go for it, because I think if all four of us could do it, any of you can. And I think that's the overriding message.
Thank you, all the speakers. And I think one of the main things I've learned today is that the criminal bar is very well connected. All the speakers know each other, and hopefully one day we're able to gain as the same connections, and if not more. So thank you everyone for attending. Thank you to the Queen Mary Bar Society, Queen Mary Criminal Justice Society, and the Queen Mary Open Law Society for organising this. Special thanks to Hamza for organising all the breakout rooms, moving everyone around, moving me around to all the breakout rooms as well. I was on a little tour to see how it's going along. And thank you to the attendees. Good night.